Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to cover the case of the Queen and Biya. There's two reasons. One, a couple of people have asked me, what happens if you have a trial and the judge gets the evidence wrong? They either mishear it or they misunderstand it, and that leads them to a bad decision. Well, this is one of the things that the appeals courts deal with, and this case provides an example. It's also got some fun firearm issues involved in it and some fun other issues. So let's dig in here. So the appellant, Abdullah Biya, appeals his conviction and sentence for charges relating to the unauthorized possession of a firearm and ammunition, possession of a Schedule I controlled substance, that being MDEA, which is similar to MDMA, but it's a different chemical, for the purpose of trafficking. So they're not just alleging that he possessed this, they're alleging that he was also planning on selling it to someone else or giving it to someone else or along those lines, and possession of the proceeds of crime in the amount of $1,725. So essentially they're alleging he's a drug dealer with a gun and drugs, and that the money was obtained from dealing drugs. The appellant's main argument on the conviction appeal is that the trial judge materially misapprehended the evidence in rejecting the appellant's third-party suspect defense. So this is a fairly simple phrase for a lawyer, but I'll break down key bits here. Materially misapprehended means that the judge got something wrong about the evidence, and the material aspect of that is that we're not going to worry just about anything that the judge gets wrong. It's got to be something that the judge gets wrong that matters. So let's say two people are out on the street and the allegation is they're dealing drugs, and a car passes by that, they don't stop that car. It's just something that happens. And a witness says that the car is blue, and the judge, in their reasons, mentions the car and describes it as a green car. That would be a misapprehension of the evidence. But if we don't care about that car, if that car doesn't matter, then it's not going to be material, and thus they're never going to ground an appeal on that. That makes sense, right? And the third-party suspect defense aspect is essentially the accused is saying, it's not me, maybe it's that other guy. And they don't have to prove that other person did it. This would just be, is there a reasonable doubt, when we think about this other person? Could that other person maybe have done it? So the appellant claims this error leaves the trial judge's reasoning on which the conviction depends on unsteady ground, resulting in a miscarriage of justice. We agree with the appellant. For the reasons that follow, we allow the appeal, quash the conviction, and order a new trial. So the conviction is struck out, but the accused isn't done. It's not that he just walks out of there and is a free man. He's instead got to have a new trial in which they will try to convict him again. And maybe next time they'll convict him without sort of any errors. So he's still on the hook. Background. On September 11th, 2015, I kind of feel like that's a bad day for crime, because that seems like a day when police might be just a little more paying attention. Just a thought. The police received a tip that a person was selling drugs outside a Drake concert at Ryerson University. I'd actually be kind of shocked if no one was selling drugs outside of a concert. But that's neither here nor there. The person was described as a black male with cornrows, wearing a black t-shirt, and carrying a bouquet of flowers and a red and black Good Life gym bag. The bouquet of flowers I don't get here. Are they trying to make it easy for the cops? Like, wouldn't it be easier to carry some sort of flag or something like that? Because otherwise this might not be the most precise description, but a bouquet of flowers really narrows it down. Oh well. Police officers located a person matching this description talking to two other men at a gas station. The police watched the three men and noticed that when a mounted police unit approached the area, the men slinked back into the gas station. When a second mounted police unit approached, the men retreated further and entered a Honda SUV parked at the gas station. The appellant had the gym bag and bouquet with him when he entered the driver's seat of the Honda. The officers did not see who had control of the gym bag after the three men entered the Honda. A group of uniformed police officers and two plainclothes officers huddled for between 1 to 2 minutes about 30 meters from the Honda. That's not that far. The men inside the Honda could see the officers. The police believed the men inside the Honda noticed the officers approaching when they were 5 to 10 meters away. Now, I kind of wonder about this. Like, that's the police's belief, but we see that these individuals have retreated. It's entirely possible that they were noticed before that, but I can't say for certain. The officers could see the appellant, who was in the driver's seat, and Simeon George McCool, who was in the front passenger seat. They could not see Javon Moore, who was in the back seat directly behind George McCool. The appellant's gym bag and flowers were also in the back seat directly behind the appellant. I'm just going to stop here and say, whoever hyphenated that name made a terrible mistake, because really, if you've got the opportunity to just be named McCool, come on. How do you pass that up and you decide to hyphenate it? That feels like a minor tragedy to me, that we don't have a McCool who's charged on this one. 6 uniformed officers rode their bicycles toward the Honda. This took about 30 to 40 seconds. As the police approached, they saw the appellant appear nervous and wide-eyed. He shoved his hand between the door and the seat and then into the pockets of his pants. An officer also saw George McCool in the front passenger seat appearing to move quickly and looking toward the back seat. But the officers could not see Moore in the back seat. And again, George McCool is it's not a first name, last name. That's a hyphenated name. That is the saddest thing in this whole story. 2 officers approached on the driver's side and smelled marijuana. Based on that smell and the appellant's apparent nervousness, the occupants were arrested and directed to get out of the car. Moore and George McCool got out voluntarily and complied with the police. The appellant did not comply and was forcibly removed. He resisted arrest, but was quickly subdued. And I'm just going to check here. The conviction was entered August 8th, 2018. So when they're smelling marijuana, they are smelling a controlled substance at this time. And that's why they've got grounds to arrest here. The police searched the 3 men incident to arrest. So having arrested them, they get to do some searching. Again, I've mentioned this in previous videos, but they can search for weapons, instruments of escape, and evidence. So on George McCool, the police found cocaine, marijuana, and MDMA in the bag he was carrying as he got out of the car, 3 cell phones, and $1,070 in cash. On Moore, the police found $1,080 in cash, but no drugs or drug packaging. On the appellant, the police found packaged marijuana and $1,725 in cash. In the driver's seat area, the police found a cell phone and a digital scale. So cell phones are commonly used by drug traffickers for their operations, and we see, 3 cell phones on one person. However, cell phones are also commonly used by everyone else, and sometimes they make a lot of, put a lot of weight on multiple cell phones. But in today's day and age, a lot of people have more than one cell phone. You might have a personal phone and a work phone. It's not uncommon anymore. The digital scale, however, is much more of an indicator of trafficking. Many people have digital scales. They're just usually in their kitchens and not in their cars. And drug trafficking, or drug packaging equipment is another thing that is commonly sort of an issue. The police searched the gym bag incident to arrest, and at the bottom of the bag found a handgun, ammunition, a bottle of MDEA pills, and packaging like that used in the packaged marijuana found on the appellant. They've also found some of the appellant's personal items, including 2 condolence cards. The appellant was going to a funeral visitation for a friend's mother later that night, which I guess explains the bouquet. All 3 men were charged with various offenses. The charges against Moore were later withdrawn before trial. Now, this accused has had his conviction vacated, so he's presumed innocent at this stage. I don't know if he's ultimately going to be convicted or not. That'll be something to get sorted out down the road. However, as a general point of principle, if you have something important happening later in the day, you probably don't want to start the day with criminal activity. It might interfere with your plans. All 3 men were charged with various offenses. The charges against Moore were later withdrawn before trial. Trial judge's decision. The appellant and George McCool were tried together. The trial judge convicted George McCool of possession of cocaine and MDMA for the purpose of trafficking. The trial judge inferred from the quantities of drugs he had in his bag as he got out of the car that the drugs were in his possession for the purpose of trafficking rather than personal use. George McCool did not appeal his conviction. I bet he's kind of regretting that now. Neither the appellant nor Moore testified. The appellant did not dispute he had knowledge and control of the marijuana found on his person, but he did dispute any knowledge of or control over the gun, magazine, and pills in the gym bag. His defense centered on Moore as a third-party suspect. He posited that Moore had 1 to 2 minutes in the back seat to place the contraband in the bag while the officers huddled across the street and then approached the car in plain view of the 3 suspects. He claimed that Moore had on his person a quantity of cash consistent with drug trafficking, but no contraband because he had stashed it in the gym bag. The appellant also adduced Moore's criminal record for gun and drug trafficking offenses to show his propensity as a third-party suspect. Not a great friend, right? If you're thinking, if we accept his version of things and that Moore went, oh no, it's the cops, I'm going to stuff all of my contraband into my friend's bag that is full of his stuff at that point, that's a real jerk move. And we see that Moore's charges were withdrawn before trial. So if that's what happened, it really worked out for Mr. Moore. The reason why he's showing the criminal record is basically to say, listen, this is a guy who's done this before. You can't use that sort of evidence typically as to prove that the accused did it, unless the accused somehow puts that in issue. But in this case, they can use it to sort of show that it's a possibility on this third-party suspect, that it's not just sort of pure conjecture. The trial judge rejected the appellant's third-party suspect defense and convicted the appellant. She found that Moore did not have the time to remove the magazine from the handgun and to stow the handgun, magazine, and bottle of pills at the bottom of the bag. She also found that Moore did not have the opportunity and propensity to have had the firearm, ammunition, and pills on his person and to have put them surreptitiously in the gym bag as the police approached. She found there was no real evidence for this proposition, which she found was speculative. Finally, the trial judge found overwhelming evidence that the appellant had knowledge of and control over the contraband in the gym bag. She noted that the packaging in the bag resembled the packaging of the marijuana found on the appellant. The condolence cards were for a visitation the appellant was to attend that evening. The appellant had been seen carrying the gym bag. Drugs such as MDEA are often sold at concerts, where the appellant was arrested, and the cash found on the appellant was in smaller denominations. I'm guessing there must have been some admissions. It seems to me, and this is pure conjecture, I don't have the underlying sort of case in front of me, but it seems to me I don't know how they would have established that the condolence cards were for a visitation that he was going to, unless he'd talked to them and made some admissions about those condolence cards, which you can see here ends up being really powerful evidence against him. You might not think, and let's sort of take a step back. Let's assume that he doesn't know that there's anything in this bag. Let's assume that he thinks that this bag is clean. And so he's just telling the police, oh yeah, there's, those cards are for a funeral I'm going to. He may not realize at that point just how much he's digging himself into a hole. So this is again why lawyers emphasize, do not talk to the police, even about things you think are innocent, because an admission that those were his condolence cards can really dig him a big hole here. The trial judge sentenced the appellant to 4 years incarceration, less credit for pretrial custody and bail conditions, and various ancillary orders. Ancillary orders are sort of orders outside of the time, so orders like firearms bans and that kind of thing. The appellant now appeals his conviction and seeks leave to appeal his sentence. So he's trying to appeal both the conviction and the sentence. And the reason why you'd appeal both is that the court might say, listen, we think the conviction is good, but we're going to allow your appeal for sentence and reduce your time. But in this case, if you win on the conviction appeal, the sentence appeal basically becomes moot. Nobody cares about the sentence appeal at that point because you're not convicted anymore. So discussion. Although the appellant advances several grounds of appeal from conviction and sentence, we've concluded that the appeal should be allowed because the trial judge materially misapprehended the evidence in concluding that Moore lacked enough time to remove the magazine from the gun and place it in the gym bag. The trial judge then repeated this error in concluding that Moore did not have the propensity and opportunity to have placed the contraband in the bag. These errors led the trial judge to conclude erroneously that there were no reasonable possibilities inconsistent with the appellant's guilt. The uncontradicted evidence was that the police huddled for 1 to 2 minutes and then took another 30 to 40 seconds to bike to the car, all while in plain view of the car's occupants. The elapsed time was therefore between 1 minute 30 seconds and 2 minutes 40 seconds, during which the police could not see Moore because he was in the back seat. The trial judge explained her reasons for concluding that Moore did not have enough time to stow the contraband in the gym bag as follows. I'm not satisfied that it would have been possible within the time frame from the police approaching the vehicle to Mr. Moore and Mr. George McCool and exiting the vehicle for Mr. Moore to have taken all the items from his person and put them in the bag, and particularly taking the magazine out of the handgun and stowing the handgun, ammunition, and drugs at the bottom of the bag under all of the other contents. I do not find this to be feasible and reject this argument. However, there was no evidence before the trial judge as to how long it would have taken to remove a magazine from a gun or this magazine from this gun. There was also no evidence that the magazine was even in the gun and needed to be removed. The trial judge therefore misapprehended the evidence on this point. So first of all, the magazine might never have even been in the gun. They might have been two separate items, and just pull both items out of your pocket, stuff them in the bag. That's one possibility, and the judge failed to consider that. But the other thing is that there was no evidence about how long it would take, and that's something that the court is going to require some evidence. Somebody's going to have to tell the court how long that takes, and the court's not really going to be in a position to just take judicial notice of that, which means that the court, without evidence, sort of determine something is true because it's obvious. So as an example, you might take judicial notice, for instance, of the fact that water can be used to clean something. That's an example of something that is so patently obvious that maybe you don't need specific evidence for it. So we have a bit of an advantage over the trial judge because we can do an experiment here. So I've got a Tokarev handgun. You can see nothing in the chamber. Magazine, also nothing in the magazine. And how long does this take to drop the magazine? So 3, 2, 1. Real fast. 3, 2, 1. Fraction of a second, right? It's if you're thinking about that and then putting things into a bag, that seems fairly straightforward and easy. So this is not a lengthy or difficult process in any way here. Could that have happened within the time frame of 1 minute and 30 seconds? Well, if it was with the Tokarev handgun, yes, it absolutely could have. If it was some other handgun, maybe not. I have a Browning Nomad, and one magazine that I have for it tends to stick and would take a fair bit of sort of wrenching to get out. I try not to use that magazine because it's terrible, but there's a possibility, that a particular magazine might be overly difficult to remove. So the Crown concedes that the trial judge misapprehended the evidence, but contends the misapprehension was not material. The Crown asserts that even if this finding is excised, the other evidence the trial judge relied on allowed her to conclude that Moore had insufficient time to put the contraband in the gym bag. We do not accept this submission. The trial judge herself highlighted that her conclusion was based particularly on the lack of time to remove the magazine from the gun. Her own wording suggests this error about the substance of the evidence was material to her reasoning in rejecting the third-party suspect defense. Striking this error in the assessment of the evidence from the judgment leaves the trial judge's reasoning on which the conviction depends on unsteady ground, leading to a miscarriage of justice. So, once again, it's not a long time here. The trial judge repeated this error in concluding that Moore did not have the opportunity and propensity to have surreptitiously placed the contraband in the bag as the police huddled and approached the car. She stated, "It is the position of counsel on behalf of the appellant that the police had huddled with one of the other police officers for 1 to 2 minutes before they approached the car, and that the lapse of time was sufficient for Mr. Moore to have taken the seized items from his person and put them into the gym bag in the back seat behind the driver's seat. As set forth above, I do not accept the arguments of counsel for the appellant, which suggests that Mr. Moore had the opportunity and propensity to have had the firearm, ammunition, and drugs on his person and put them surreptitiously into the gym bag, when the police approached the vehicle. There is no real evidence for this, and I find the proposition to be speculative. I reject the submission. The trial judge did not separately address Moore's opportunity and propensity. She seems to have rejected the appellant's third-party suspect defense only because she found that Moore lacked opportunity. However, Moore's criminal record provided a reasonable basis to claim he had the propensity to have placed a contraband in the gym bag, and they cite some cases. His criminal record included several recent firearms and drug-related convictions for robbery with a firearm in 2012, possession of a Schedule I substance in 2014, and reminder, this is a Schedule I substance here, possession of an unauthorized firearm, breach of a firearm prohibition order, and possession of a Schedule I substance in June 2014, possession of an unauthorized firearm and breach of a firearm prohibition order in July 2014, and trafficking in a Schedule I substance in 2015. The trial judge thus erred in summarily rejecting the third-party suspect defense. I find myself wondering how long he'd been out of custody in 2018, given those convictions. It might have been that he was actually fairly fresh out of custody. But if you've got somebody with all of those firearm and drug-related convictions, it seems plausible that maybe the gun and the drugs were his and not the other guy's. So conclusion, the trial judge erred by convicting the appellant based on a material misapprehension of the evidence about Moore's opportunity as a third-party suspect. There was also evidence that Moore had the propensity as a third-party suspect, which the trial judge failed to address. The trial judge's errors leave the conviction on unsteady ground and resulted in a miscarriage of justice. However, because there was evidence on which a properly instructed trier of fact could reasonably have convicted the appellant, the appropriate remedy is to order a new trial on all counts under, and they cite section 686 sub 2 sub b of the criminal code, which is the appropriate one. There is no need to address the appellant's request for leave to appeal the sentence. So they're not going to consider that at all, as I said before. The appeal from conviction is allowed, the appellant's conviction is quashed, and a new trial is ordered on all counts. So I think this is a really fun case. There's a lot of fun elements to it, but it also provides a good illustration of the role of appeals courts. In this case, they're stepping in to fix a problem that was made at the lower court level, and in the Canadian system, you know, this isn't a situation where the accused just walks away because of that mistake. Instead, they're going to have another trial, and potentially they could get convicted. You see that the appeals court says, because there was evidence on which a properly instructed trier of fact could reasonably have convicted the appellant. That's a fairly low test. That actually mostly means that there's some evidence on all of the key points and that it's possible to convict on that basis. But because the trial judge relied so heavily on things that weren't in evidence or where they were in error, there has to be a do-over here. So if it was a situation where absent that mistake, it wouldn't have been possible to convict the appellant, then they wouldn't have ordered a new trial. Instead, what they would have said is, we're going to strike out the conviction and enter an acquittal in its place. And that would have been the end of it, unless it was appealed up to a still higher court. Anyway, thank you for watching. As I said, I think this is a fun one. Please like this video. Please share it with your friends. Subscribe to see more content if this is a new video to you. I also want to thank my Patreon supporters. At the $50 level, Sir Daniel Wicks of Alberta, Jason Elliott, D. Moe, Canada's National Firearms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited, and at the $20 level, Dale Nesbitt, Cameron Johnson, and Andrew Elsich, as well as a number of you at the $10 level in the crawl immediately following. Thank you once again for watching, and I hope this has armed you with knowledge.